and then tell me when to start talking.
Okay. You can begin.
I thought you were going to start it. Oh, okay. Okay. I'll start then. Hello, everyone. My name is Ken Vercammen, and I'm an attorney from Edison, New Jersey. And we try to have a program at the Piscataway Library every year to go over wills, probate, living wills, the do's and don'ts. And since we can't go to the library, they're kind enough to set up one of the first Zoom library programs in the state of New Jersey. So that is good news for the library, good news for everyone. So oftentimes, though, people will ask, well, why do I really need to have a will? I'm married, or a lot of my accounts have joint beneficiaries or payable upon death. But there's always assets that there's no beneficiary. So if someone does not have a will, or their will was declared invalid because it wasn't properly prepared or wasn't properly signed and is not admissible to probate, well, problems come up. Number one, the procedure to distribute assets becomes much more complicated. So if, let's say there's 3 kids, that would mean all the children got to select someone to become the administrator of an estate if there's no will. And the other children have to sign a renunciation affidavit in front of a notary. And if all the children don't sign a renunciation affidavit in front of a notary, then it would require the person who wants to become the administrator to have to file a complaint and order to show cause in the Superior Court. Cost over $3,000. Well, preparation of a will for under $4,000 eliminates this cost. 2, if there is no will and there are assets, the person who becomes the administrator has to take a thing called a surety bond. In a way, it's like an insurance policy that they have to take out. Some people can't even qualify for the credit, but most people usually will say, hey, I'm leaving everything to my kids. This one's going to be number 1 executor. I trust them. Why should they have to spend $1,000 on the surety bond? I'd say 3, if someone does not have a will, state law determines who gets assets, not you. And more people are deciding, hey, do I have to leave everything equally to my kids or to my grandkids? And the answer is no. And we'll go over that later on into the program. I'd say if someone does not have a will and no close blood relatives, the state of New Jersey gets the money. And I don't know who would want the state of New Jersey to get their money. Nobody. But also a lot of times it causes stress and fights within a family, sometimes lawsuits. And when someone's passed away and it's time for grieving, they shouldn't be overwhelmed with having to worry about one other thing. So for people looking to do a will, if they have children, young children, sometimes we look at, hey, who would, if something happened to both parents, who would you want to be the guardian of kids? Let's say, or to safeguard the children's money for college. Without a will, children or grandkids get their money the day they turn 18. How many 18-year-olds have done really smart things with money? 0. They would go out and buy a red fast car. They would go to Seaside, and they'd buy a lot of video games, and they would play around. So there's reasons why we want to have things done. And people often put off getting documents done because, it's so complicated. No, it's not. It wasn't complicated before the pandemic, and it's not complicated now. Because what we've done in the past, we either mail or email or fax a questionnaire. With things in New Jersey being closed, I'd say, well, I always say, hey, there's this new thing called email. We email the questionnaire to everyone. And in the questionnaire, we have people type up responses. People put off things, it's so complicated. Well, it's not that complicated. What's your name? Are you married? Who's going to be executor 1? Who's going to be executor 2? I'd say, and Also, one of the things that we tell people is that we recommend that there be just one executor and then a second executor, not joint executors. And the reason why is because if there's joint executors, even if they get along, let's see, that means both of them have to do everything. Two people got to go to the surrogate's office together. Two people got to sign the contract to list with a realtor. Two people have to sign the contract to sell the house. Two people have to sign the addendum. Two people have to sign every check. Two people have to sign every document. So it's better to have one and then another. There's a reason why there's only like one governor at a time and not co-governors. There's a number one and a number two. On the other hand, sometimes you get matters where the two executors that are joint, they don't agree. So in that case, there's no easy tiebreaker. There would have to be a complaint and order to show cause going to the Superior Court, and anything before the Superior Court is never a inexpensive or easy process. Now, believe it or not, New Jersey did away with the tax. Who would have thought that? New Jersey did away with the estate tax last year. So we used to ask many detailed questions on people's assets, but now for the there's still a federal estate tax, but that's $11.5 million. So I asked the people, are your assets more or less than $11.5 million? Everyone says no. We do ask them about where they have real estate, because a will that's done in New Jersey is valid in any other state. But if someone has real estate in other states, there's still a process that has to be done in the other state that's called ancillary probate. And I'm going to get later on, I'll touch upon one of the questions on trusts, but right now we're talking about wills. So, people put off getting wills because sometimes it goes, well, I got to put together a list of all my assets, etc. I tell people, I don't want to know, I don't need to know your personal stuff, unless it's more than $11 million. Then we get into, okay, in your will, who do you want to get your assets? I'd say typically, people often say, okay, to my spouse, then to my kids in equal shares. If any of my kids shall predecease, then to their children, my grandchildren. But more and more people are not doing it that way, because it's your right to do what you want with your assets. You can't leave a spouse penniless, but other than that, as long as you still have a good mind, you're able to do things. And one of our clients said, under the law, do I have to treat all my kids equally? And I said, no. What is your concern? She goes, well, one of my sons, we don't hear from much. He lives in California. He goes, well, I go, on your birthday, did he get a call or a card? She goes, no. On Christmas, did he get a call or a card? No. On Mother's Day, did he get a call or a card? No. Then I said, well, your question is whether or not you should leave someone anything where they've had no contact with the family. Why do they deserve to inherit what you've worked on? Some people don't leave assets to spouses, not because we don't care about the spouse, but the spouse may already be in a nursing home or going to a nursing home. So instead we leave it to kids. Sometimes you have children that are on Social Security, and we don't want to leave assets to them because they lose their Social Security benefits. State Bar did a program last year, and we called it estate planning when you have the difficult or problem child. Because people that have special ed children know, hey, we have to protect them. But a lot of people are reluctant to write someone out that may have like drug problems, alcohol problems, gambling problems. But, giving someone who has a problem $100,000, $200,000 is not going to help them cure their problem. It's going to make them worse. So in those instances, we can set up within the will that's called a spendthrift trust. And one of the other kids or someone you trust becomes the trustee of that money, and it can be used for that problem kid's support, but they don't have access to it. So in one of the cases, a spendthrift trust was set up, and the trustee used the money to pay for the guy's uh, apartment, to pay for car insurance on a reasonable car. And because the guy had alcohol problems, we didn't want to give him any money. So instead, we would buy ShopRite gift cards, because you can't buy booze at ShopRite, and they would be sold and given in small denominations, like $25 a piece. This way, it was more difficult to peddle it out for money. Now, people also, when they're preparing the documents, we want to ask, is how many children do you have? And then we get into what's called specific bequests. Now, what's a specific bequest? Well, a specific bequest is where someone's leaving an amount of money to a child, or let's see, sometimes it's a charity or someone. It's an amount, rather than everyone sharing in equal shares. Now, some people say, okay, I want to leave $10,000 to my church. I want to leave $20,000, $15,000 to my grammar school, my college, my high school. Some of the libraries have foundations. They can leave money to the library foundation. Some people have left money to the senior center, because you say, listen, that's where I've had the most joy in the last years of my life. I like to leave something so that everyone can have like a cake. But it's, sometimes women will say, hey, I'm leaving my jewelry to my daughter or my granddaughter, because they realize that, hey, guys don't appreciate stuff like that. And the ladies know that if their son is the executor, he's going to take the jewelry, bring it to Cash for Gold, and goes, hey, what do you give me for this junk? And well, some people will say, I want to leave it to my granddaughter because this was my ring or my jewelry, and at least for a time being, it will be within the family. Some of the men sometimes say, I want my firearms to go to a specific person in the family that has a firearm permit and will use the firearm. So those are some easy examples of specific bequest. But we also sometimes have what I call the reverse specific bequest. And that is, I make no bequest to this person or that person. We don't put a reason. We don't leave $1. Just, I make no bequest to that person. Let's see. A client redid her will and said, hey, I'm leaving everything equally amongst my 2 kids, but if my one son dies, then that share goes to my other son, because I haven't heard from my grandson in 4 years. He doesn't acknowledge any of the gifts I give him now, so I can always change it later on. So, so those are some of the things that you want to think about when you're doing your documents. I mentioned earlier, if people have minor children, think about who can be the guardian of the children. And there's never a right person to raise someone, but some of my clients, like, it's difficult for them to, because they can't think of the right person. I goes, well, you don't have that many people that are candidates, and who don't you want? So, and I said, that person who would not be a good candidate has the equal right to go in front of a judge in the Superior Court probate part and ask to become the guardian. So it's easy in a way, I ask people, okay, if you couldn't leave this room, who do you want to watch your kids for the next 2 weeks? And this is one of the reasons sometimes where parents that have grandchildren encourage their own kids to have wills, where they say, listen, you should have a will, I'll pay for it. And also make sure you put in a clause that says, I get custody of my grandkids in the event something happens to both of you. There's someone that becomes the trustee of minors' money. It can be the same person. Sometimes it can, or It can be like different people. And so now a will that's done in New Jersey is valid in any other state. But there's a difference sometimes between what is valid and what is best for someone. So my mother-in-law used to call me every other year and say, "Oh, I want to come in and get a trust done." And I would ask her, "Were you watching Susie Orman?" And she said, "Yes." I go, Susie Orman is totally right if you live in New York, California, Florida, where the probate process is very, very complicated. But New Jersey, the probate process is easy. It's very easy. So I ask people like, why do you want to spend $3,000-$4,000 to have a trust when a $400-$500 will will do it? And you know, if the only answer is avoiding probate, I'll usually say, well, probate costs about $150, so that has not saved you any money. Ironically, let's say, yeah, this program is being recorded during a time when the buildings are closed and people can't get around. So what's the benefit of a trust? Well, one of the benefits of a trust is the day that someone passes away, that afternoon, the trustee has the power to start distributing money. When there's a will, they have to, first make sure that the surrogate's office gets the original will, a death certificate, a check for $150, and then wait for the papers to come back from the surrogate. Now, in most instances, having to wait 10 days, 15 days is not a process. But, in the spring of 2020, it is a process because you can't walk into the surrogate's office. You have to, fill out a form, have it notarized, send it in to them. So that becomes a little bit more complicated. So now I had some questions on wills somewhere, and one of the complicated things is having to deal with screens. So let's go through some of the some of the questions before I go on to some of the other sections of our program today. Question: how do you set up a trust for a minor, young adult, or college student? Well, typically, it's easy just to simply do it within the will. So, when in the wills that we do, when there's minors, we set up a trust within the will. That's called a testamentary trust, because it doesn't come into effect or get funded until the parents pass away. And in a testamentary trust, it says this is for kids, for example, they get some money when they're 22, some when they're 25, the balance when they're 30. But the trustee can expend as much money as is needed for health, education, support, etc. But for example, a person passes away, there's a trust set up. The person finishes college and then says, like, Uncle Jay, listen, I'd say I graduated college and I got a job and I'd like to buy a condo, where I'm going to be having my job. Uncle Jay would say, okay, that's a smart thing to do. I will advance you the money now, or we will take the trust money from your parents and use that towards the condo. On the other hand, let's say the kid's 20 years old and says, hey, Uncle Jay, college is very difficult for me, and I like to take a sabbatical because it's very stressful, and I need $70,000 because my buddies and I want to take a trip across Europe. And Uncle Jay can then say, you better work more hours at your crummy part-time job since you dropped out of college, because I'm not taking your parents' money and using it so you can goof off instead. All right, so it doesn't make sense to set up a trust for a minor, a standalone trust, and fund it, because there's no there's no real benefit to that. I did mention a benefit of having a trust where someone passes away, but you got to also think about who's going to be the trustee. I'd say someone asked to save on cost. Does a sweetheart will need to be updated? Well, New Jersey has no legal thing called a sweetheart will. I don't know what that is. Let me though talk about cheap things online that people fill out and think that they are good. Let's see. Zig Ziglar was a motivational speaker, and he said, "Hey, there's not a sign in the fudge shop in Atlantic City that says cheap fudge." He goes, "Their sign says good fudge," and then he makes the comment, good things ain't cheap, and cheap things ain't good. So, well, one of the dangers of these online forums is sometimes people don't fill them out correctly, and or they're not signed properly. So, in New Jersey, attorneys do what's called a self-proving will, and that was a change in the statute a few years ago. So, what's a self-proving will? Well, under the old law, it simply required two people sign, then the person signs, then two people sign. But then one of the two people had to go in front of the surrogate's office and sign an affidavit saying they were a witness, not just sign an affidavit in their house or speak to the surrogate. They had to go into the surrogate's office and sign this affidavit. And people were charging exorbitant fees, saying, "I want $500 to do it." So the legislature created a thing called the self-proving will to dispense with having the witnesses have to go to the surrogate's office. But what that requires is the person signs, then two witnesses sign, then the attorney or notary signs, and then we do it again with some additional language. So therefore, since the person signs twice, the witnesses have signed twice, the attorney notary has signed twice, none of the witnesses have to be found. They don't have to go to the surrogate's office. It makes it easier. And many people don't go through this, these cheap forms they find online don't have the self-proving will. So then they're going to, if they can't find the witness, it becomes a problem. Also, I mentioned earlier, if there's no will, there has to be a thing taken out called a surety bond. Well, if the will that's prepared, the cheap thing that someone found online, does not specifically say no bond is required, the county surrogate says, "Sorry, you have to take out a surety bond at your expense, and we can't. Otherwise, you can't become the executor because the will didn't say that." So, it's the importance of having programs like this is so that we're trying to educate people a little, I'd say, but afterwards, we also talk about the call to action and don't put things off, get them done now. Let's say one of my clients, said, "Oh, you know what? I like to read up a little bit more on this." Let's say, and because he was from the retired generation of readers, and this guy probably had books and books and books in his house. And I said, "Mr. K, I've already read for you. You don't need to read anything." Let's say, I went to seminars. I do seminars for the bar. You don't need to know what the law is. And I told him, "Mr. K, when I need a knee surgery, I call the Rutgers track coach." He goes, "Hey, who's the best guy you got?" And they gave me this guy, University Orthopedics. And the only thing I asked the doctor, goes, sarcastically, because he was the Rutgers football team doctor, I'd say, "Are you good at doing knee surgeries?" And he goes, "Kenny, I do professional athletes' knee surgery." So I said, "Okay, that's good. That's good for me. I don't want to read anything all about knee surgery. I knew that I was going to go to someone that's qualified." Now let me look at some of the other quick questions. Let's see. We'll touch upon probate at the end. Someone asked, I'm 59. I have a will that was created 10 years ago by an attorney. A will that was done 10 years ago is still valid. But I do suggest that people look to it to see, number one, does it have a clause that says no bond required? Otherwise, the family would have to take out a bond. Two, was it a self-proving will? I'd say, if not, get a new one. Do you have the original? Remember, only, I'd say, an original will can be admitted to probate. Think of the surrogate as a fancy name for the will clerk, but it has to be the original. It can't be a photocopy. So sometimes people say, I can't find my original will. If that, so our rule of thumb is, if you can't find the original will within 72 hours, you're probably not going to find it, and get a new one done. Let's see. A living will that's more than 10 years old is fine. A power of attorney, when I touch upon power of attorneys, I usually suggest a new one be signed every 5 years or so. That is not a state law requirement, but the problem is sometimes banks give people a hard time. And sometimes banks say, oh, well, this is, 15 years old. How do we know the person's still alive or it's still valid? Also, I've been suggesting that people sign a new power of attorney if addresses change, because the problem we see with banks and the institutions are, someone could go in with a perfectly good valid document, the power of attorney. They could have the original, and the bank says, okay, let me see your ID. And the ID has a different address. And you could say over and over again, well, I moved, this is where I'm at now, but that becomes a problem. Okay, next question now. Are online wills legal in New Jersey? Well, let's say they had to be signed. Something that is only on a computer is not a will. To be valid and be admitted to probate before the surrogate, it has to be written. It has to be signed, original ink. It has to be witnessed by at least two people who are in the room or close by. And then I suggested, that'd be a self-proving will. Now, in this spring of 2020, what's our other issue that we've had? Well, there's a governor's order that says no group meetings and 6 feet apart. So what our office has been doing for people is, we call it we prepare the documents online without people having to travel to our law office, and we have follow-up consults over the phone. I did the FaceTime thing a couple times, but I found my clients didn't want to do the FaceTime because it was one more thing they had to learn how to do it, and people don't like the way that they look on screen. Let's say it's kind of like your voice. You when you hear your own voice, you say, "Ew, that sounds terrible." And so a lot of my clients say, no, I would just rather talk to you over the phone. So logistically, what we've been doing in the spring is, I mentioned we email someone a short questionnaire. Then they type up some of the details, and they save it as a Word document or text, not a PDF, because this way we can actually cut and paste it into the documents that we do, so we're not spelling anyone's name wrong. Let's see, people can pay online by credit card or by PayPal. Let's say we prepare the documents, we call people up, and then as of April 22, people have been signing in front of the notaries at the UPS store with as the witness a spouse and another family member. Let's say starting next week, because the governor in the orders, there's essential businesses that can stay open, businesses that must close, like hair salons. The library must close, but the liquor stores can stay open. However, what we're going to be doing is on the nice days, we're going to put a table in the middle of the parking lot, and I'm going to have chalk lines 7 feet out, not 6 feet, but 7 feet out. and I'm going to say, okay, we're all like we're more than 7 feet apart from each other. You're going to sign where that X is. Then you're going to sign again, and then the witnesses go forward. And then I tell the people, okay, go back to the cars, and I'm going to notarize it, make some copies, and we'll send you on your way. Because it's important to stay safe, but still get your important documents done now, because people have been going to the hospital. Let's say we got calls. My dad is in the hospital. He's at JFK. Can you go out there and do a power of attorney? I goes, they're not going to let us in the dude. And I will not do a document unless I've spoken to the person, because there's undue influence concerns that I have to be 100% sure that's what the person wants and not what their kid wants or some other family wants. Because going back when I was a young lawyer starting at my office, it was one of those first nice days of spring where fellow calls me out, goes, oh, my dad wants to have a new will done and sign the house over to me. He goes, but he said, the guy goes, my dad has a bad leg. He can't get around much. Can you go to the house? Yeah, sure. I go to the house, and this is before we emailed out forms. This is before, because you're anxious. I'm anxious to help people. However, get to the house, and the son brings me in. He didn't live with his dad. And the son goes to his father's watching TV and says real loud to the dad, he goes, Dad, this is an attorney, and he's going to explain to you why you should sign the house over to me. And the old man looks up and goes, who? What? And the son had to say louder, this is an attorney. He's going to explain why you should sign the house over to me. And at least the old man had the smarts to say, I'm not signing the house over to you. You'll sell it and kick me out. And that's when I realized that the father had no clue that anyone was, that his son had tried to put me up to this. So my rule of thumb is I either do it right or I don't do it at all. I don't do anything that to jeopardize my license. And sometimes we have the smell test. And if it smells bad, then don't eat it. And legally, if it smells or looks bad, then I'm not going to do it, because again, it's not about money all the time. It's about doing the right thing. And I remember years and years ago when I was in school, and the teachers back then, the teachers could hit us. And I remember, but they were trying to instill a little bit of smarts and morality into us. And that's, some of the things that I've learned. Okay. Does someone need a lawyer to make a will? The answer to that is no. But just when I was a young man, my dad taught me how to change my own oil, and I wouldn't think about doing it now. Let's see. My first house, I tried to do the electric work by reading a kit put out by the hardware store, and I almost burned the house down. So I says, you know what? Let's have someone who's a professional do it right. Another question, issues, online tools. Well, like Susie Orman. Well, one of the things with Susie Orman, Susie Orman is a New Yorker, and they're big into having trusts. And having a trust means you're taking the assets out. These are New York trusts. You're taking the assets out of your name and putting them into the name of the trust. So basically, you don't own it anymore, I'd say. And the Susie Orman type trusts are revocable trusts, so it does not protect or shield any of the assets in the event someone has to go into a nursing home. So whenever someone says, I would like to have a trust done, I always ask, why do you think you need a trust? And sometimes someone may say, that they say, I have some medical issues, and if I have to go into nursing home in 5 years, I want it shielded. Okay, that would make sense. But just to avoid probate, that really doesn't make any sense at all. I did. What if someone is separated? Let's say, if someone is separated and things aren't good, then number one, you should speak to a matrimonial attorney. But also, it is a good idea to do a new will to say, hey, anything that I have, I don't want it to be to my soon to be cheating ex. I want it to go to either my kids or my parents or someone else. Also, it is very important to do a new power of attorney if you already have one, because uh, if someone has a power of attorney and they named their spouse, well, people do crazy and evil things. And if there's a power of attorney and all, someone is like becoming separated, you don't want them to be able to loot your assets. Um, Now, I mentioned earlier, if someone gets divorced and has a name change, for convenience sake, sometimes it would be very wise to have a new power of attorney done because um, the assets are going to have a different name than the new name. So in those cases, I say, listen, you talk to wherever the attorney you did. When I'm just revising documents in my office, like we don't charge that much because they're on the computer. Sometimes it's just a matter of changing a couple lines and the year. But the important thing is when the office is open again in a week or so, if you don't already have a will, including many of the people on this call who I know or this program, go out and get one done. There was a question on second marriage situations. Well, a second marriage situation is a good area where people set up trust within their wills to say, listen, some of my assets are going to go into a trust for the benefit of my spouse if I go first. And they're able to take out so much per year, but upon their death the assets go to my children, not their children. uh, Under matrimonial law, assets that someone has before they're married do not count for what's called equitable distribution if someone is getting divorced. Let's see, unless they're put into joint names. Let's see. So a home that someone owned before they got married, that's theirs, and the new spouse doesn't get that through divorce. But what you don't want to do is have a will that says, okay, my new spouse and I decided that everything's going to go to each other and then get split between our two families. And the reason why that is no good is because, let's say, the next week, one of the spouses could go out and have a new will done. Let's say I got that call one time. Second marriage. I said this is what they insisted upon doing. I said, listen, anyone can change. Oh no, this is what we want to do. Well, a week or so later, the lady calls me and goes, you know what? I changed my mind. I want everything to go to my kids and not to him. And I had to say to the client, ma'am, I can't do that because you and your husband were my clients together. And I can't do, as long as he's alive, I can't do a new document that's contrary to what your joint estate plan was. I said, let me be honest with you. Let's see. You can go to any other lawyer in New Jersey except me or the lawyers in my office. And I didn't hear from her. And 3 or 4 years later, her husband died. She called me up and goes, okay, can I come in and get the will redone now? And it turns out she only had about $50,000 or so. It was her assets. And I said, okay, I feel good about doing it that way because it passed the smell test. On the other hand, let's say if she would have inherited $700,000 from her husband and she was going to screw the husband's kids, then I would be uncomfortable with that. We're going to, in about 10 minutes, we're going to touch upon the probate process. There is a question, how many people can be the executor. And I mentioned you want to have a number one and a number two. You never want to have joint executors because I mentioned earlier, when it's joint, you need two people got to do everything, and that's usually not the best way of doing things. Okay. Okay. So we've covered now a great deal about um, wills, touched upon probate, trust, touched upon trust. Let's next talk about the power of attorney. And now, a will takes care of your assets if you pass away. What is a power of attorney? A power of attorney is now while you're alive, but let's say you become incapacitated. You know, you know, nobody plans on becoming sick, but we see based upon the pandemic, people that were in perfectly good health are on respirators in the hospitals. And I'd say no one ever thought that. We used to be able to go to hospitals and sign documents. Now the hospitals say, stay out, stay out, stay out. You can't even go in there if you're a family member. So what do we need in the power of attorney? Basically similar to a will, there's a number one and a number two. And now there's two types of powers of attorney we sign. Let's see, they're either effective right away or they're effective only upon disability. Let's see. And it's better to be effective right away because if it says effective only upon disability, you have to if someone becomes disabled, they have to get notes from doctors and then convince the bank or Wells Fargo, or not Wells Fargo, either bank or these the money institutions, Merrill Lynch, Morgan Stanley, that the person is in fact incapacitated. So we usually recommend that it become effective right away. When it's effective right away, it's called a general durable power of attorney. Durable power of attorney. If it's effective only upon disability, it's called a springing power of attorney, which means that it springs into effect if someone becomes disabled. So it's better to be effective right away. We had a client, and he goes, "Kenny, you're using legal words on me." He goes, "I'm a Mason. Explain to me in Mason language." And not the Masonic, is a bricklayer type Mason. He goes, "Explain to me in my working man language." I goes, "Okay, if it's effective right away, your son can steal all your money right away. If it's effective only upon disability, your son has to get a certification from your doctor saying you're disabled before he steals your money." Having said that, do you trust your son? And he goes, "I trust my son with my life." I goes, "Well, then make it effective right away." A different fellow said, "I don't really trust any of these people." I goes, "Well, maybe get new family or new friends, but then don't make it effective right away." What are some of the things that a power of attorney can cover? Real estate, transfers and sales of stocks, bonds, working with your brokers. But one of the things we did add in a couple of years ago was access to medical records under the federal HIPAA law, and to make decisions under the PULST, and directing that healthcare providers shall release information to the person you selected. We also look at, there used to be a problem, there was a problem a couple of years ago where some of the banks, again, were giving people hard times, and they were saying, "Well, it wasn't done on our countrywide power of attorney form, so we're not going to honor it." So the legislature came up with a law that says if it makes reference to New Jersey statute and they do business in New Jersey, they have to honor it. Otherwise, they're in violation of the New Jersey banking and insurance laws. However, it has to make reference to Section 2 of PL 1991, C95, C46:2B-11. And I'm pretty sure that the cheap or free things that you find online are not going to have reference to this New Jersey statute. And when you try to bring it to like Morgan Stanley or Merrill Lynch, they're going to say, we're not going to honor it. But on the other hand, if it's, we use that language, and every once in a while, some institution starts giving my client a hard time, and we goes, listen, that's the law. And those, oh, the law says this, it has to be one bank. It has to be within 6 months. It goes, that's not a law. And it goes, tell you what, here's what we're going to do. We're going to file a complaint with the Department of Banking and Insurance against your institution. And we're going to also name you because you're violating New Jersey law by not honoring this legal document. And after that happens, usually we get someone like from the institution, a higher up person, to then try to work with us. But again, having a power of attorney is important because, hey, no one can ever pick when you're going to be hurt or whatever. Let's see. I'm a pretty fit person. If it wasn't for this pandemic, I would have been doing a 60-mile bike ride for the Franklin Food Bank on Sunday morning. But on the other hand, one year I was biking from South Brunswick down to the shore, and I flipped over the handlebars and broke my collarbone. That's the hurty part up here, and I'm left-handed. I couldn't sign anything for weeks. My power of attorney said, hey, if something happens to me, I can't sign. My wife could sign for me. But I'm blessed that I only broke my collarbone and not anything worse. So having a power of number one, you want to have a power of attorney. Number two, you want to have like the will, last will, and testament. And the next document we're going to talk about is the living will and durable power of attorney for health care, advance directive for medical care, etc. Because I usually tell people that is the document where, someone's in the hospital, they're no longer responsive. It's they're in a terminal condition, they're in a coma, they can't talk for themselves anymore, and you want to have that document so that the family doesn't have to make the ultimate decisions on things. Because I remember when a doctor asked me that, the question, okay, should we remove life support today? And I'm like, geez, doctor, I feel bad. And I knew what the right decision was for someone who's 92 years old that wasn't going to leave the bed, wasn't going to regain consciousness, wasn't going to be able to enjoy another day. But you hate to be the one where you say, okay, yeah, let's go flip the switch. So the good thing, in a way, with the living will advance directive is you are already saying, okay, these are what my wishes are. As to the extent possible, please follow up my wishes. So in the living will advance directive, there's a section that deals with life-sustaining treatment. And I tell everyone, I took the language word for word from the medical society, New Jersey Medical Society's language. This way, doctors familiar with what's there. Sometimes people say, well, I'd like to change this. It goes, no, leave it there. This isn't Ken Vercammen's language. This is the Medical Society's language. So let's talk about fluids and nutrition for a second. Section A, fluids and nutrition shall be withheld and withdrawn as life-sustaining treatment or shall be provided. So probably now about 80% of the people say, you know what, if there's no hope for me, I want, fluids, nutrition, feeding tubes to be withheld. I'd say more people would say I wanted to be provided because they were under the mistaken position that their religion required that all means be taken to, keep someone alive. But I've spoken with priests, I've spoken with ministers, I've spoken with rabbis, and they all say, No, that is not true. They don't believe in mercy killing. They don't believe it is appropriate where the right to die law in New Jersey, but this is a little different where when there's someone's in a terminal condition, there's no hope for them. Then the next section deals with other medical treatment. I usually refer to it as the machines. And with the machines, there's different boxes, but 99% of the people initial 1, 2, 3, 4, because number 5 says, I direct all medically appropriate measures be provided to sustain my life, regardless of my physical or medical condition. So basically, someone says, I want to be kept alive for as long as possible. So 99% of the people say, I don't want to be kept alive. One lady, it was kind of interesting. She came to my office for the purpose of, she goes, oh, I need to have a new deed done. I need to get my my husband's name off. Okay, when can he come in? She goes, I haven't seen him in 15 years. He goes, well, where is he at? Somewhere in Pennsylvania. He goes, well, lady, you can't just get your husband's name off a deed. She goes, yeah, but I've been paying the mortgage for 15 years. He goes, yeah, but you just, are you divorced? No. I goes, well, that's a problem. And she goes, why? He goes, well, whoever dies first, the winner gets the house. So she goes to me, goes, so you mean to tell me that if my husband, who I haven't seen in 15 years, if I die tomorrow, he gets the house? Yes. So then she says, okay, in my living will, I need to be kept alive one more minute than him so that he would be getting, nothing. But I said, listen, I said, I will do it that way, but that's, in a way, that's not good estate planning. What I do suggest, I said, I goes, forget about that, the Catholic Church is opposed to like a divorce. Let's see, you got to get either a divorce and get him off the deed, have the judge award you the house, or find him and get him to sign you a quit claim deed now. And she goes, well, I think he's in a nursing home somewhere in Pennsylvania. He goes, well, that is not good either, unless you're hoping that he passes away. Which unrelated in a way also to the living will is some people get unmarried. Let's see, that's the divorce word, but unmarried sounds nicer. And they'll say, but they never go and have a new deed done to transfer the house into their name. And that becomes a problem down the road. And just in the past a couple months, I've had different ladies come in and it goes, well, in my divorce decree, it says I get the house. And I says, that's nice. So the only person on the planet that knows about that is you, your divorce lawyer, and the judge, because the county clerk has no knowledge of that, and that's not only a new deed filed with the county clerk can properly put the house into that person's name. Okay, but let me go back and finish up though with the living will part. We changed our living wills to provide for a HIPAA authorization that the person you selected, similar to the power of attorney, similar to executor one, shall have access to medical and hospital records under the federal HIPAA law and to make decisions under POST. And healthcare providers can release medical information to your agent, and obviously it expires upon your death. So as the years go by, there's different things that we do to change our documents to make them better. So, for example, in our wills, we have a clause now that says, my executor shall serve as my funeral agent, because even though the will is not admitted to probate until it has to be more than 10 days, at least it's in writing, because sometimes families fight over who's going to be the captain of the ship. And one funeral home says, Kenny, whoever pays the bills, determines it. But under the New Jersey um, uh, Act, funeral agent is the one that controls for the purpose of funeral. Now, in the living will, we also some people have someone different as their agent to make any last decisions regarding someone's health care, because the doctor could come and say, listen, there's a procedure that we just started doing here and at Robert Wood Johnson that we've had some success, but since we can't get consent from dad because he's sedated, do you want to try it, yes or no? It's the last hope. The living will has a clause also that says organ donation yes, organ donation no. And I always suggest people sign it no matter what their age or what their health. And let's see, I went to an interesting program put on by the NJ Sharing Network that deals with organ donors in New Jersey. And I said, what's the maximum age to be an organ donor? And they said, there is none. I goes, well, what's good on a 85-year-old guy? And they said cornea and skin. I goes, oh, I never thought about that. If I was burned, I'd rather have 85-year-old guy's skin than the stuff that got burned off me. I also asked them what diseases or illness disqualifies someone from being an organ donor. And at the time, they said the only disqualifier was HIV. And then last year, that law was changed. Someone from who has HIV can be an organ donor to someone else that has HIV. So sometimes people, can donate a kidney. So someone with HIV can donate a kidney to a partner. Now I'm about out of time. April, were there any other questions I didn't touch upon?
Yes. There was one question actually that came through the chat. It's actually a clarification of an earlier question. It's from Kate. It says, my will was signed by the attorney, one witness, a notary, and me. Is that sufficient for a self-proving will? It was 10 years ago.
Okay. Probably because the attorney can serve as a witness. Let's say, so as long as you have there has to be two human beings over 18 as witnesses, and then an attorney or notary at the end. So that's probably self-proving. But sometimes the easiest way is you pick up the phone and you call up that attorney. Goes, hey, I just want to clarify. Is my document a self-proving will? There is a question that I didn't completely go through. What is the probate process? New Jersey, believe it or not, is the probate easiest state. I mentioned the surrogate gets the original will, does to check for $150 or so. They mail you the documents and they say, good luck to you. Let's see. There's no follow-up by the surrogate's office. Unlike other states, like the reason why people do trusts in New York and California, Florida, because the process is very expensive, very complicated. Everything along the way has to be approved. New Jersey, the surrogate just says, oh, good luck to you. Now, there's things that are supposed to be done. You're supposed to send a notice of probate to all the beneficiaries in the will and anyone that would have inherited if there was no will. And if there's a even though New Jersey has no inheritance tax if it's going to children or grandchildren, spouse, or parents, if there's a house, we still have to obtain an inheritance tax waiver on the house and certain other bank accounts. If it's not going to those people or charities, then there is an inheritance tax that has to be paid. At the end of the case, once the executor has paid the bills, put all the assets into an estate account, then either you have to file a superior. The easiest way is all the beneficiaries sign what's called a release and refunding bond, saying that, okay, I got the informal accounting from the executor. It looks good to me. Send me my money. But everyone has to sign this release and refunding bond in front of a notary, and that gets filed with the surrogate. Okay, what's the difference between an executor and a trustee? Executor handles the will. A trustee holds the money for the minors or the people that should be holding money. And any other estate matters? Okay. Someone wrote, we already have an estate plan trust. Well, let's see. Uh, what happens sometimes when people do these trusts is they don't fund the trust. So a trust usually says, okay, the assets that are owned by the trust. So when trusts are usually done by attorneys, in addition to the trust, there's a pour over will that says, hey, any assets that were not retitled into the name of the trust um, are going to be transferred into the trust and distributed pursuant to the trust. All right. I went through probate process. Executor and trustee can be the same human who can be the executor um,
We
and
have another question in the chat.
okay, go
From,
for it.
from Heidi, can you touch on considerations for someone who does not have children as far as designating beneficiaries?
Well, I had someone was concerned that the people they selected weren't blood relatives and they would be taxed. And I goes, well, so what? You're going to be gone. Let's see. Pick the people that were nice to you. Pick, you know, and someone can change their will and every other year as long as they are mentally okay. So someone says, okay, this question comes up almost every program. Okay, I don't have children, I don't have grandchildren, and I don't really hear from my outside family members. They goes, well, okay, think about worthy charities, nonprofits, or people that were nice to you. There was a little lady in North Plainfield that when we did her will, she left money to her, some of her neighbors and her hairdresser and someone else from her that she knew that was helpful to her and made sure that she was okay if she didn't show up for church or didn't show up for bingo. And because the idea was that she goes, these people were nice to me because they're good human beings and they weren't looking out for money for me. But remember, if there is no will and people don't have immediate family, either the state of New Jersey gets it, or the people that didn't invite you to, weddings, family events, they get it. And why should they deserve it when there's people probably deserve it more? Did that answer that question, Joy? Are we good?
I think so. There's
Okay.
no response in the chat.
So, okay, so let me just conclude. Okay, my name is Ken Vercammen. I'm an attorney in Edison, New Jersey, and let's say we have a website, njlaws.com. So, just about any question you may have on probate, there's an article on the website, njlaws.com. But rather than read, I tell people pick up the phone and call us up. I talk to people, I email people the questionnaires. And I mentioned, let's see, New Jersey, like talking about spouses, let's say, you can't leave a spouse penniless because you can, but then the spouse can what's called elect against the will, but they have to prove that the person who passed away had substantially more assets than them, which sometimes I've told people not. I'm not anti-marriage, but some of the older people, I would say, why would you get married at this point in time? Do you understand that if you got married on a Thursday and your spouse had a stroke and went into a nursing home on Monday, that once they run out of assets under federal law, you're responsible for this person? Let's see. So again, I'm not anti marriage, but I'm pro making sure that your money goes towards your immediate family. And with that, Joy Robinson, are we good?
Yes, we're good. Oh, wait, hold
Okay.
on. I see one more question coming up.
Yeah.
Um, So the question, must I leave anything to my spouse? $1?
No, I use the word, I leave nothing to whomever person. We don't put a reason, just I leave, just so there's no clarification. The whole thing of leaving $1 or $5,000 was, that's something from the movies. Let's see. You don't use, I leave nothing to X. Here's the problem. If you leave $1, then the estate stays open until they cash that dollar check, which they're never going to do. In the TV show on HBO, Better Call Saul, where he was Saul Good. It was originally Jimmy McGinty, and he was left $5,000, and the estate would stay open until he cashed the $5,000 he was getting from his brother's estate. So we leave them nothing, because otherwise we're waiting for them to sign a release or a funding bond saying they've gotten their money. So with that, I'd say thank you, everyone. And whether or not it's my office or someone else, then you want to have your documents done. Was there one last question?
No, that was a thank you. That was a thank you.
Okay.
Okay.
I see things blinking. Okay.
Yeah.
And at some
Okay.
point, the library will have a link to the recording, correct?
Correct.
Very good. Okay.